Okay, well, good afternoon, or depending where you are, good morning or good evening, and a very warm welcome to the second phase of the International PhD in Progress weekly seminars. This is a series organised by the Global South Network, and the first phase of them ran from May until August this year, and we had students and staff from 8 different disciplines, about 22 universities in 8 countries. And as those who were lucky enough to join any of the sessions will know, it was all very inspiring, and everybody, I think, learned a lot from the different discussions each week. So this current phase will start today, so it's the first one now, and will end in December, so at the end of the year. And I'd like to thank formally the organiser of the series, who's Dr. Noman Riyat, that you can see here. He'll wave so that everybody knows who he is if they can't see his name or initials on the screen. And he is a lecturer in law at Leicester Law School and also the convener of the Global South Network. That's a network which Noman created. And without further ado, and there will be people joining as we go along, so you'll see them just pop up on the screen, allow me to introduce today's panel. I am Rhona Smith, and I'm a Professor of International Human Rights at Newcastle University, and also, as I mentioned, co-convener of the Global South Network. I've got a background in human rights and human rights capacity building in a lot of universities around the world, particularly in Global South countries, and I've also held visiting positions in various institutions too. I will be chairing the session today, and I'm joined by Dr. Asmahan Musaya, who's a lecturer in law in Crimminology at Leicester University, and Emilia Oris-Onyiri, who's a PhD candidate at the School of Law in Nottingham University. And they will be respectively the discussant and the peer commentator for today's session. Emilia is a doctoral researcher in Nottingham in the law school, and her research interests are in international trade, finance and economic law. But she's also qualified as a barrister and solicitor in Nigeria, and she therefore has got practice experience too. So that's our panel for today. And that means I can now introduce our speaker. So Iona Mcentee is a PhD candidate at the University of Glasgow. So she'll be in the same time zone, but probably with torrential rain and winds battering the windows at the moment in the west of Scotland.
Yep.
And after completing an LLM in Global Environmental Law and Governance in 2020, she became a member of the Strathclyde Centre for Environmental Law and Governance thereafter. And she's been developing her research within global environmental studies, and her research is grounded within the rights of nature discourse, with a focus on analysing the extent to which interjudicial exchanges can accommodate the diffusion of subaltern epistemologies and act as a gradual and kind of piecemeal approach to decolonising global law. Her presentation this afternoon is entitled Rights of Nature, Inter-Judicial Exchanges and the Decolonisation of Global Law. And the structure of our afternoon is that, Iona, you'll have 25 minutes for the presentation. There will then be 5 minutes for the comments and questions of both the discussant and the peer commentator, and we will then open the floor for comments. Iona has managed to get her presentation working and uploaded, which is a great start to our session. So without further ado, I'll pass over to you. Thank you.
Thank you so much for that wonderful introduction, and thank you again for the invite to present my work here. I really appreciate it. So I'll just kind of move on and show the structure of my presentation today. So first of all, I would like to introduce my overall PhD project, hypothesis, some initial assumptions and some research questions, to then move on to a brief discussion about the methodology I use. The main focus of this presentation is going to be on demonstrating my research findings, because I've recently done a case study analysis of a diffusion of epistemologies from New Zealand to India. So I'll focus on that. And then following that, I'll just summarise some interim conclusions. So, summary of my PhD project is surrounded around the hypothesis that interjudicial exchanges between domestic courts have the capabilities of diffusing the legal epistemologies of the South and can act as gradual and piecemeal approaches to decolonising global law. So this is on the assumption that I believe that interjudicial exchanges can act as tools for subaltern emancipation in the manner that they can assist the diffusion of subaltern legal phenomena in a manner which can contribute to this bottom-up decolonisation of global law. So in order to analyse the diffusion of these subaltern epistemologies, I test my research within a rights of nature framing. This is in particular a recognition that rights of nature discourse has famously been emblematized by sort of legal and legislative precedents set by countries which have been formally subjected to colonial domination. So a couple of examples that you'll probably know is like the constitutionalization of Pachamama in Ecuador, the recognition of the legal personality of rivers, such as in New Zealand, Colombia, and India, and so on. So following that, I kind of center my research around the following research questions, which I'll unpack a little bit later as well. First one, to what extent are interjudicial exchanges between courts in the countries formerly submitted to colonial domination diffusing subaltern legal phenomena? To what extent are these interjudicial exchanges through a rights of nature framing accommodating or hampering legal ecumenism between pre- and post-colonial legal traditions, and where the diffusion of subaltern epistemologies are accommodating the development of a subaltern rights of nature jurisprudence and also accommodating legal ecumenisms, what role does this play in the bottom-up decolonisation of global law? So, just to kind of unpack the specific terminology of legal ecumenism, because I rely on it quite a bit within my research. So legal ecumenism, I seek to assess the extent to which rights of nature are accommodating or hampering legal ecumenisms between pre- and post-colonial legal traditions. And I've drawn this definition from the works of Boaventura de Sousa Santos and his recent edition of Towards a New Legal Common Sense. And it's relevant in framing the ability of different legal orders and their ability to overcome strict dogmatic boundaries that often divide and hierarchically organise different legal orders so that they can alternatively coexist on a hierarchical plane. So this is based on the ability of different legal orders within pluralistic societies to articulate their differences, such as social ordering, value preferences, and cultural orientations, so that they can foster their coexistence based on mutual respect and recognising these differences. So therefore, by recognising and respecting these differences, these societies can then foster closer relationships and hopefully collaborate with one another, if so desired, with the intention on bettering their peaceful coexistence. So later on the presentation, I'll highlight the sort of this application of legal ecumenism. In particular, we'll see it being accommodated in the New Zealand context, where there are tensions between different legal orders, aka Tikanga law, which is Maori customary law, and Pakeha law, which is, the inherited common law from the British colonial era, and how the application of rights of nature has helped overcome these tensions. So moving on to the methodology of my research, so I intend to analyse the contribution of interjudicial exchanges to the decolonisation of law by focusing on the extent to which domestic courts in countries formerly submitted to colonial domination are relying on foreign precedents to inform their decision making and are integrating these epistemologies accordingly. So I focus on case studies where there is a diffusion of subaltern legal phenomena, and I hope to demonstrate how interjudicial exchanges of rights of nature epistemologies are actually contributing to a development of a subaltern rights of nature jurisprudence. So my research is centred around a couple of case studies. The focus of this presentation will be, the diffusion of epistemologies from New Zealand to India, but I later also hope to test the diffusion from New Zealand to Colombia as well, because I've managed to trace sort of explicit exchanges of legal materials from Colombia, India, because they both explicitly cited and relied on the precedents created from the jurisprudence in New Zealand. So that is my example of an interjudicial exchange, which is the primary case studies for my research and then my primary focus. But in order to kind of highlight this complex network of, multi-directional exchanges, I've also had to highlight instances in which these exchanges are also occurring between the judiciary to the legislature. So in sort of events where a judicial precedent has influenced a foreign legislative development in another country. But I will be focusing on the sort of interjudicial exchange. So just focusing on my first case study. So I use New Zealand as a sort of like base point, as it was the first country to recognise the legal personality of rivers by attributing rights to the river to the same status of humans. So this was a legal saga that lasted over 140 years, which was between the Maoris and the Crown government. And this legal argument was then crystallised within the Whanganui River Report, which was the outcome of the Waitangi Tribunal. So then this was later then the outcome of the River Report was then translated into the Whanganui River Act and also influenced the creation of the Te Urewera Act of 2014. For the purposes of this presentation, I'm going to focus on the Whanganui River Act of 2017, as that was the direct outcome of the Whanganui River Report. But just to highlight, the same reasoning that was used in the Waitangi Tribunal for the Whanganui River Report was also applied in the Te Urewera situation, as they also relied on the argument of using culturally based legal reasoning. So just to kind of give some context, I know it's 140 years, so I can't quite possibly cover everything, but just some context on the sort of dynamics of this sort of saga of between the Maori and the government. The Whanganui iwi first petitioned the Crown government in 1873, and this was with two key goals in mind. The first one was to address years of degradation that had been inflicted upon the river in order to preserve the river's health for future generations. But the second one was to get an acknowledgement and retribution for the years of discrimination experienced by the Maori in relation to their sort of colonial grievances by the Crown. So as a big oversimplification of these cases, the substances of the Whanganui River saga was centred around contestation of ownership and possession over the Whanganui River, to which the Maori as the plaintiffs stated that they never freely or knowingly relinquished their ownership rights over the river with the signing of the Treaty of Waitangi in 1840. So therefore they asserted that the Crown's acts and omissions were violating their rights. Just for context, the Treaty of Waitangi was signed between the Maori and the Crown government and gave the Maori standing and a voice in New Zealand. Notably, throughout this sort of litigation process, which went through several courts and also like parliamentary petitions, it was the Court of Appeal that stated that the Crown had ownership title of the riparian land because they relied on the sort of English common law doctrine of ad medium acque, and also stated that the Whanganui iwi's ownership had also been extinguished and therefore passed to the Crown when they relied on Section 14 of the Coal Mines Act Amendment Act 1903. However, when the Maori then again petitioned but brought a case to the Waitangi Tribunal as sort of a last port of call, because this had been years and years afterwards, in order to try and get some justice, it was the Waitangi Tribunal that changed this narrative, and they instead focused on the substance of whether the Maori had freely or knowingly given up their rights. Accordingly, the tribunal found that the Crown was actually in violation of the Treaty of Waitangi for the following reasons, which includes that they demonstrated that the Maori had not voluntarily given up these rights, which was demonstrated by the manner in which Maori engaged in protests, petitioning and litigation, and therefore stated that the Crown had actually violated Article 2 of the treaty, which guarantees the ownership of Maori over the river as long as they wish to retain these possessions and also do not willingly dispose of or alienate this sort of land to the Crown. Secondly, they highlighted that there had been no explicit agreement between the Maori and the Crown for the relinquishment of land in relation to the river. And thirdly, the alleged extinguishment of Maori customary rights and ownership was based on the Crown's own statutes and presumptions of English law, as in the Common Law Doctrine, Ad Medium Acque, and also Section 14 of the Coal Mines Act. This actually violated the English Laws Act of 1858 and the Doctrine of Aboriginal Title, because the English Laws Act was meant to mean that English law would only apply to the sort of British settler colonies in New Zealand, and therefore to allow Indigenous groups to be governed by their own practices. So in this manner, the Crown violated Article 2 of the Treaty of Waitangi on the basis that the Maori had not given up their rights, and also because the Crown's acts and omissions had actually failed to protect the Maori sovereignty over their treasures, which is also known as their tonga, and they associate their treasures with, these parts of land as well. And that was meant to be guaranteed by Article 2, so it was a violation there. And notably and very importantly throughout the saga, one of the key components has been the conflict between these two legal orders, between the Maori law and also the English law, on the conception of ownership. As in the English law doctrine, nature is seen as a commodity to exploit and have economic gain, and there's this sort of dynamic of humans have the ability to do this over nature. It's seen as a commodity, whereas in the Maori perception, it doesn't align with their worldviews at all. They don't perceive nature as a commodity to be exploited. I'll talk about that a little bit more because to talk about the sort of cosmovisions that were integrated into the Act. But yeah, the conflict between the two legal orders was a key fact. So legislative outcomes of the Waitangi Tribunal was the creation of the Whanganui River Act and also Te Urewera Act. But then the creation of the Whanganui River Act in particular, as I said, in order to kind of overcome these tensions between these two legal orders and to kind of give a voice to the relationship and perception of the Maori with nature, they enshrined this relationship that was specific to the Whanganui iwi and to the Whanganui River in the legislation. And most importantly as well, they had a settlement of $80 million to redress the damage that was ensued by the Crown, and also recognised the Whanganui River, which was also known as Te Awa Tupua, as an indivisible living entity, one which encompasses the surrounding areas and all the elements from the mountains to sea. So, looking particularly at how rights of nature has been constructed in New Zealand in accordance with the Whanganui River Act, as I said, one of the most important integrations was understanding the specific relationship between the Maori and nature. And integrating that, the legislation recognised that Te Awa Tupua is an indivisible living whole and comprises the Whanganui River from the mountains to the sea and incorporates all of its physical and metaphysical elements. Now, I've underlined metaphysical elements because it's such an important integration to understand this relationship, because the Maori recognise the nature, as their ancestors and as their kin, and see that there is a spiritual and physical authority and power between the two, and it's got this spiritual life essence. It's in this manner that the relationship is incredibly important because it's based on reciprocity, and they have trustee obligations between one another, because nature provides sort of physical and cultural sustenance to the Maori, and then the nature depends on the Maori for their conservation, their protection, and enhancement. So it's a relationship built on respect, and they both benefit from each other. It's not the sort of hierarchical relationship in which the Maori dominate over nature. It's very different to the Western legal tradition. Also, very importantly, there was the creation of a guardianship body on behalf of nature, because they needed that human face, because the legislation recognised that the Te Awa Tupua has all the rights, powers, duties and liabilities of a legal person. And therefore, in retaining these rights, a guardianship body had to be created in order to carry out the legal duties on behalf of the river. Also, very notably, a co-management approach was incorporated into the Whanganui River Act and also the Te Urewera Act, in which there would be a representative from the Maori community specific to that piece of nature, and also by the Crown Government in representing nature. And this is notable for 2 points, because it was to ensure proper representation of those who had a vested interest in these natural spaces, but also it was meant to be quite symbolic in representing the intentions of Maori and Crown cooperation, to hopefully move forward and cooperate with one another to have a sort of peaceful coexistence in the post-colonial era. So, notably as well, as I've already spoke about, there's this clear dynamic of conflict between Takanga law and Pakeha law. And the whole substance of the Whanganui River saga was centred around these sort of issues of ownership, and how the understandings of ownership in the English law, ideology was completely irreconcilable with the Maori's cosmovisions and Maori law. So in this manner, we can see here what we're talking about is conflicts between pre and post-colonial legal traditions. And then therefore I've reflected upon this in order to assess to what extent has rights of nature sort of accommodated or hampered legal ecumenisms by overcoming these conflicts between these two legal orders. And throughout my research, I believe that in this situation, rights of nature has actually accommodated legal ecumenisms to a certain extent, because it's allowing for the integration of these specific cosmovisions and sort of helps to overcome these conflicts between Maori and Pakeha law by creating a space for the inclusion of these subaltern epistemologies. And therefore it creates a sort of heterarchical space in which they can both exist instead of a hierarchical space in which one cancels out the other. Whilst this seems good, and it's a development in the right direction, I would like to think, there have also been limitations in this, because at the end of the day, rights of nature is still, by a lot of Maori communities, is seen as a Western legal paradigm, and they don't really agree with it, they don't associate it with it, because they don't see as nature being something that can be granted legal personality. It's just a very different mindset. So therefore, in situations like the Whanganui saga, where they're having 140 years of trying to achieve forms of justice, rights of nature appears to be one, if not the only avenues to achieve this form of justice. But inevitably, it's made that Maori communities are having to engage in a legal regime that's irreconcilable with their worldviews. So it's a bit controversial. And furthermore, there have been limitations in the application of rights of nature in the way that it's not been able to fully realise some emancipatory claims. For example, in the case that preceded the Te Urewera Act of 2014, the Toho and their claim against the Crown Government wanted to actually regain their dispossessed land. But this was basically not on the table. The Crown said they would not be willing to engage with such a request. And as a compromise, they then offered, acknowledging the legal personality of the Te Urewera and the sort of institution of the co-management approach as a compromise. So therefore, the two who they weren't able to realise their full emancipatory claims, and instead were compromised. However, although there are limitations in the sort of application of rights of nature, it still has had benefits, I would say, and contributing to the sort of internal decolonisation of New Zealand, because it's giving a platform for these other epistemologies from general jurisprudence, and it's allowing for law and policy to be developed in a more subaltern framing. To which a couple of examples, since the Whanganui River Act and Te Urewera Act, we've seen the 2018 implementation of a redress framework for the Wagehu River, and also the 2021 recognition of Mount Taranaki's legal personality. So that's the internal influence of these epistemologies, but we're also starting to see external influences in which the epistemologies set in New Zealand are actually influencing legislative developments in other countries. For example, in Australia, shortly after the Whanganui River Act, the Victorian Parliament recognised the Yarra River as an indivisible living entity in 2017, and then later in Canada in 2022, the National Assembly of Quebec did a first reading to confer rights onto the St. Lawrence River. So these are cases where there's not been an explicit acknowledgement, but the manner in which legal personality is being integrated into these places are similarly constructed, and we can kind of see that there's an influence or a sort of snowball effect of these epistemologies. Now turning to the sort of focus is this inter-judicial exchange. There has been an explicit integration of these New Zealand epistemologies in India. So, for example, it was in 2017, which was 1 week after the recognition of the Te Awa Tupua, the Indian judiciary first granted their two most sacred rivers, the Ganges and the Yamuna, as having human status, and then later also granted the Gangotri and Yamunotri and all the surrounding ecosystems the status of living entities. Now, as I said, in both cases, the Indian judiciary cited epistemology set both from the Whanganui River Act and also Te Urewera Act. And we can see a sort of similar construction in the way that their rights of nature has been crafted by following suit in the way that legal personality has been crafted, and also a guardianship body. I'll talk about this in a second. But despite the sort of legal innovations, the Supreme Court later stayed these judgments. And whilst it was down to legal complexities and ambiguities with the implementation of rights of nature, I argue that this is also down to the judiciary failing to adopt a tailored and bespoke rights of nature solution that was tailored to the internal value preferences of India and also the sort of like societal circumstances. That'll be a really important point, because this is how I assess the ability of places to accommodate or hamper legal ecumenism, because I do believe that applying a more bespoke rights of nature solution has more likelihood to accommodate forms of legal ecumenism. So looking at the manner in which India has integrated these precedents, they have directly cited them, of course, but as I said, they have modelled their rights of nature construction also quite similarly. So we can see this by the way in which legal personality was crafted. So they sought to frame the recognition of the Ganges by defining the unique spiritual, cultural and religious relationship held with the Ganges and the glaciers. In this manner, the court actually iterated that the river Ganges and Yamuna are worshipped by Hindus. The rivers are very sacred and revered. The Hindus have a deep spiritual connection with the rivers Ganges and Yamuna. According to Hindu beliefs, a dip in the river Ganga can wash away all the sins, and the Ganga is also called Ganga Ma. So it's in this manner that the judiciary tried to define legal personality in response to the human development and needs and faith of Indian society. So in addition, they also, as I said, constructed a guardianship body to act on behalf of the Ganges and the glaciers and to act as a human face. Alternatively, they relied on their own sort of doctrines of legal personality and used the parens patriae doctrine, which has also been used in situations where corporations have been granted legal personality and allows an individual or a group of individuals to act on behalf of them. But notably, I'm going to look at how it has deviated from the New Zealand situation. One situation it deviated was that the guardianship body was not actually comprised, was only comprised of state officials. In this manner, this has actually deviated from what Christopher Stone has suggested in his seminal work, Should Trees Have Standing, in which he suggested that a guardian or a trustee body should be comprised of people who have a dedicated and invaluable connection to nature, as they are identified as the most appropriate representatives. So in the New Zealand context, the Maori were obviously seen as the most appropriate representatives. In addition, there's an issue with this because there's no independent third party. So then representing nature in the Indian context, and then this may become an issue where the government's acts and omissions are actually violating nature's rights, and therefore questions to what extent the sort of guardianship or trustee body would then hold the government to account when they have violated these rights. And also, on a final note on the guardianship body, it also means that those with a vested interest are excluded from the management and protection of these spaces and fall short of the sort of participatory model that was advocated for in the New Zealand context. Now, the last two deviations I'm going to focus on more so because they're more important to frame how the application of rights of nature hampers legal ecumenisms to a certain extent. Now, this is in the manner that India did not actually tailor the rights of nature epistemologies to the internal value preferences and social climate. And this highlights how there's limitations with direct transplantation of legal phenomena. First of all, because it impacted the Supreme Court's decision on the legal application of these epistemologies. As the Supreme Court later stated the judgment, as I already said, because the full status of rights, duties and liabilities of the river were not clearly defined. And so the Supreme Court said it led to very complex legal situations because it was very ambiguous. One example of this, of it being complicated, is that the River Ganges actually flowed through multiple states. And was the High Court had the jurisdiction to adjudicate on the substance of this case, it did not have the authority to set up an institutional management body, which would be necessary for the regulation of the Ganges, especially in a participatory fashion. Furthermore, the lack of tailoring a rights of nature approach was also apparent in the way that the decision has been somewhat maybe contrary to the ideology of India being a pluralistic democracy, because the sort of recognition of the legal personality of nature based on religious reasoning didn't resonate very well with all Indians, especially because there's a large portion of Indians who do not perceive nature as sacred. So this has then kind of been controversial for not only promoting exclusionary tendencies of people's connections to nature depending on their religious beliefs, but also because the application of religious beliefs, religious epistemologies may potentially undermine India's secular stance. So this is very different in the New Zealand case, where the inclusion of Maori epistemologies was to promote inclusion, creating this heterarchical space. But there are concerns that the application of rights of nature in the Indian context might promote more exclusionary tendencies and pose risks to India's pluralistic democracy.
Iona, you've got about 2 minutes.
Okay, great. I'm almost there. So there's an issue with the sort of privileging of certain epistemologies in the manner that it hampers legal ecumenism by promoting the sort of like hierarchical ordering of epistemologies instead, and sort of impedes the sort of decolonial agendas by excluding the inclusion of specific epistemologies. But this is not to deny that there has still been contributions towards India's internal decolonisation since these very innovative approaches, which we can see in the 2020 constitutionalisation of the legal personality of Lake Sukna, and also the 2022 Declaration of Mother Earth as a Living Being. But we'll need to see what the Supreme Court has to say with this, or whether it will face the same legal hurdles. And also there's potential influences in other jurisdictions, such in Bangladesh, where there's the recognition of the River Turak in 2019, based on the doctrine of loco parentis. So just to summarise some sort of interim conclusions that I've experienced so far, I think the application of rights of nature in New Zealand seems to accommodate legal ecumenisms more so than India, in a manner that I actually perceive that it's actually accommodating forms of legal ecumenism and supporting decolonial agendas by overcoming these boundaries between these sort of different legal orders, and also by accommodating inclusion. And therefore, I do believe that applying a tailored and bespoke rights of nature solution is more likely to support decolonial agendas by accommodating these legal ecumenisms between pre and post-colonial legal traditions. So thank you so much for allowing me to present my work. If you have any comments or questions, they're more than welcome. Thank you.
Thank you very much, and excellent timing indeed. So can I first of all indicate that if anybody's got any wishes to raise any questions who is in the chat at the moment, then do so on the chat function and indicate that you want to speak, and it means it will help us when we come on to going to the next speaker. So feel free just to indicate that you wish to speak, and then we will come on to you. Secondly, in keeping with our normal structure here, we now give 5 minutes to both of the discussant and the peer commentator. So if I can first of all please extend the floor to Dr. Asmahan Musaya, who is, as I mentioned at the start, a lecturer in law in the School of Crimminology at Leicester University. The floor is yours.
Thank you very much, Rhona. Can you hear me, all of you? Yeah? Good. Yeah,
Yes,
Iona, thank you very much for your presentation. That was very interesting. I was kind of following, and I feel like you just want you to continue again and again. That's very good. I like the case studies that you have used as well. I just got a few questions, actually. That's a very general questions. One is just regarding the kind of what theoretical framework did you include when in your PhD? Because you are kind of compared, contrasting two things there, yeah? And for example, because you are talking about generally about the decolonization of the global laws. So there's two perspectives there, yeah? You can look things from more on universalism kind of things, and probably agree to what is there and what is acceptable, yeah? But you can take a different approach as well, looking things more on a local level, which will refer as the culturalism, and probably argue differently. So it depends on what perspective probably you can kind of choose and support with your case studies. So far, I see like you're talking more about emphasizing the decolonization of global law. So you are looking on probably more of a culturalism point of view, like, okay, we don't need to be, to take the colonial leaguers on hand for us to do things in the right way. So that is just my opinion, and I don't know how do you weigh that. You think that it probably could make your justification in your conclusion. If somebody else is doing the same research, they can arrive in a different conclusion if they take a different perspective from yours. What do you think on that one?
So I've actually, that's a really good question, because in my own research framework, I've actually combined so far 3 theoretical frameworks to accommodate exactly, hopefully, what you're saying. Sort of balance between universalism and cultural relativism, I've kind of adopted a hybridized framework. So I kind of rely on William Twining and how legal concepts diffuse, diffusing legal concepts in a manner that can promote this sort of cultural relativism to promote sort of like heterogeneous pluralism, but also balancing it within the sort of universal framework. And so I use this sort of universalism in the sense of having shared goals, such as decolonial, promoting decolonial agendas, but the focus is on really diffusing this pluralism. And in tandem with that, I also kind of focus on, I use Neil Walker, his Intimations of Global Law. So I actually focus on the sort of, I use the compositive perspective that he advocates for, and it looks at sort of bottom-up approaches to achieving forms of global justice. So it's kind of the relationship between global law and global justice, and he really talks about, you know, these sort of local actors and how they contribute in this accumulative and really aggregative and piecemeal fashion to the bottom-up development of law. And that I've actually got to add in an extra additional theoretical framework in addition, because I want to read the work of Pierre Legrand, because he talks about the stubborn localness, the stubborn localness of law. And he talks about how law is very culturally specific, and I think that would fit in quite nicely in there, just to kind of really embrace the plural inclusion of law. And I obviously said I use Santos as well for the sort of legal ecumenical framings, but also in the manner of promoting a sort of subaltern cosmopolitanism and transition of law. So I've kind of tried to combine 3 so far, but soon to be 4 theoretical contributions to really frame this sort of global law construction. It's a bit confusing, but it does work in my mind.
All right, thank you very much. Thank you very much. Just before I go and leave the floor to everyone else, when we talk about this kind of decolonizing the global law, what is your opinion, or the opinion of everyone else, in relation to the globalization, where most of us, for example, in criminology, we are looking on the ways in which we can bring the laws together, so we can have the specific ones. So far, most of us, especially in the global south, we are looking the way that we can kind of preserving our laws and have the more of the specific, as you talk about, the laws are very cultural specific. So we don't want it to be imposed, from the top, or to kind of embedded within the colonial leaguers. So what is the opinion of yourself, Iona, or the opinion of anyone else wants to jump in on the discussion when we talk about this issue of decolonizing the laws, and when we talk about the issue of globalization, where, for example, crime and the utilization of resources really can happen anywhere in the world. So this crime and other things can happen outside our jurisdiction. So we need to have kind of a common law, or kind of a global laws that are there to work right from the top. So kind of superseding the domestic laws. So I don't know if you can add anything on that.
No, I mean, you're totally right. And even from the readings that I've been doing, it talks about, you know, globalization is this, you know, like neoliberal, like hegemony. You know, it's a danger, because it's sort of been transporting sort of Western legal systems as the dominant legal system for such a long time. And that's had a real trickling down effect and really quashing local laws, local cultures and local practices. And I think then that's the benefit of like trying to preserve these sort of local traditions and local laws, so that they're not susceptible from these sort of colonial fear. I mean, obviously they've already been,
they're not being superseded, by the colonial.
Exactly. So I think the most important part, and I hope that's what I hope to do with my research, is focusing on including these other epistemologies, including these other laws, because for me, my understanding of what, you know, the subaltern cosmopolitan transition is to promote inclusion, because neoliberal globalization has promoted so much exclusion of these laws that maybe we can contribute to this sort of trickling decolonial effect by promoting inclusion in all aspects, not just environmental law. As you said, criminology is everywhere. So I'm hoping that, although I focus on rights of nature, I do think that the methodology that I've used could be transplanted to other areas of law, and it would hopefully have that sort of like theoretical trickling decolonial agenda. I hope that answers your question.
Yeah, excellent. I think that's the key point that everyone probably could agree on, the issue of inclusion. What we are trying to argue is not to whether we like or dislike the Western laws or the colonial leaguers in terms of the global laws, but what we want is the inclusion of what can kind of represent each society and make it, the laws or the application of law, relevant to that particular community. So you put it beautifully. So thank you very much. That's all from me then. Anyone else who have a question or contribution, then you can just jump in. Just raise your hand.
Thank you very much indeed.
Okay. Thank you.
And if I can invite everybody who does wish to speak to indicate that in the chat, that will help us in a few minutes. But first, if I can pass the floor to the peer commentator, who, as I said, is from the University of Nottingham, and that's the doctoral student Emilia Oris-Onyiri. The floor is yours.
Thank you very much, Rhona. And thank you, Iona, for your presentation. That was very interesting and very informative. So I just have a few questions. The first one relates to your methodology. Can you expatiate on why you've chosen the methodology for your research?
Perfect. Yes, so initially I'd actually chosen interjudicial dialogues. So I've recently actually made the change to interjudicial exchanges because I think it was in my master's research I actually started playing with this methodology. So it's sprung from there. But when I started to define interjudicial dialogues, I found that I was coming into conflict with the terminology of dialogue because it really emphasizes the sort of bi-directional flow of borrowing. You know, so say, for example, if I was using dialogue in the context of New Zealand and India, I would expect, you know, India's relied on explicitly on New Zealand's epistemologies and then vice versa. And I was having a very difficult time tracing this just with case law, particularly because at the start of my PhD, it was very ambitious and I wanted to do not only case law investigations, but I also wanted to do interviews because I thought interviews would be the perfect avenue to really realize what the implicit dialogues are happening, what judges are actually thinking, not writing down, because that's the real influence on their cosmologies and opinions. But because of limitation in the time of my PhD, and the sort of unidirectional flow of diffusion that I've been analysing, I've changed it to sort of exchanges. So it's kind of developed from there, and that's where I was kind of, I think that's why I've used it essentially, because I could actually trace the exchange of materials and then sort of reason what impact they're having in the internal systems of these countries.
Right, okay, interesting, thank you very much. So the second question, I want to understand how you balance the relationship, if there is a balance of the relationship between the Taikanga law, which is the Maori customary law, and the Pakela law, which is the inherited English law. Mm-hmm. So is there a balance, given their distinctions, is there a balance between both laws? And if there is, how do you achieve that balance?
So when I was investigating the sort of difference between the two, I analysed it from the point that for a very long time, the Maori law was not given the platform that Pakeha law was getting. If we're tracing the sort of the over 140 years of material, it's a lot of material, and dominating those cases and those petitions was the argument and the defence of using all of this English common law. So for such a long time, that was the reasoning. That's why they didn't have the rights to ownership. And for such a long time, the consideration of what the Maori law said was not being considered. So the sort of balancing act, it kind of came from understanding that Pakeha law was treated as superior in all of these cases until Maori law was eventually brought to the sort of same level in which that it would give a same platform for consideration. So I think I analysed that sort of balancing act by specifically looking at the Waitangi Tribunal, which later was translated into the report, as it was the first real time that I could see Maori law being brought up to Pakeha law. So I think that sort of balancing act that I'm trying to see is not as just trying to see if they're giving equal opportunity for discussion, for inclusion, for debate. So that's sort of my balancing act, and see if it's being thereafter integrated into legislative documents, such as the Whanganui River Act and Te Uruwera Act, because it's finally being integrated into New Zealand law as a whole. So that's kind of my process with that one.
Right, okay. So just to pick up on from your answer, does that mean that the Taikanga law and the Pakila law are sort of on the same level judicially?
I would like to think so. I mean, realistically, this is maybe something that I would have to do further research on, because I don't know to what extent they are really treated as equals, because, you know, the sort of colonial stain in New Zealand, although there are active efforts to move forward with this. You know, as we can see, there's a development of law and policy gradually being considered in line with these other forms of policy. But I'm not too sure. I would like to hope that they're being treated more equally, but they are being given more representation. So I think it's a step in the right direction. Whether they're truly equal, I think would require a lot more work and investigation, maybe being able to speak to people to see how judges are actually articulating these legal arguments in consideration of the law. But I think there are active efforts to include them.
Right. Okay. That's
Yeah,
good.
just to add to myself again, sorry. Yeah, just to add to what you have just said there, because the other one is more of customary law, so it based much more on the verdict, what has just happened within the court, while the other one is more of legislations, yeah, because it's just inherited, it's there. So when you talk about whether they are equal or not, probably you not find that kind of equal level of application, because the other one, it just depends on what is happening within the judiciary. So you may find that in your literature review also. Yeah, just to add on to that. Yeah.
Yeah, and I think you might also find that Maori law is not necessarily one law,
Yeah.
because what you find, I mean, I'm more familiar with the Australian setting and other Indigenous groups, but when you go into Indigenous groups and customs, they're often very disparate. They're not necessarily common, although they may have the commonality is that they're Indigenous. It's not the case if they've got the same systems you sometimes find.
Yeah, and it will reflect that society, the norms, value, and the standard of that society. So it will be more local and cultural specific. So it's much more different from something that we talk from the colonial level, something that have been imposed. So they just work in a very different level. So I don't think even you can able to compare the two, because they are just from the different sources. Right. That makes sense, yeah? Good.
Oh, 100%. I think this is also very much highlighted, because I didn't really get to speak about the Te Urewera Act, but one of the most important differences between the two is that legal personality and reflection of that specific Maori communities, because obviously they're different, have been tailored specifically to that Maori community. So the different norms and different values they have has been articulated into that, and that kind of contributes to that pluralization of different Maori discourse, because they are although under this bracket, they're so diverse and so pluralistic that articulating these differences is so important.
Great. Okay.
Any other points, Emilia?
Yeah, just one last question, Iona. And that's on, can you expatiate on the significance or the legal implication of granting human nature or legal personality to these rivers, you know, the rivers that you analyzed you're analyzing in your research, especially within the context of the rights of nature?
Yeah, so although I love the ideology of rights of nature, there is still the issue that it's a Western legal system to a certain degree, and a lot of Maori communities really do not resonate with this, because their relationship with nature is as is. It's just a fact. It's a irrefutable fact. It shouldn't have to be crafted into law to be realized as something. So there are limitations in the fact that certain Indigenous communities don't want to engage with these sort of legal systems because they're so irreconcilable with their way of being. But then it's trying to, how do we then craft it in a more ecocentric manner, or in a manner that is more attuned to these communities? So I think there are limitations in the fact that rights of nature are getting us so far, but they are maybe letting us down in the fact that it's still a Western legal system. Some Indigenous communities don't want to engage with it, and understandably so. And also for the fact that certain claims are not, because I spoke about not realizing full emancipatory claims, right? Because in a lot of these cases, people want to have their land reclaimed. Like in the Tofu case, they've had, over the years of colonialism, they had 92% of their land dispossessed. So therefore, they were wanting to regain it through this claim, but they were told, no, you cannot do it. So then I also then do wonder, because they've implemented this sort of co-management approach, whether I think there's limitations in realizing these emancipatory claims, because maybe I'm just theorizing here. So in the case where the Tohu don't want to cooperate with the Crown government on this, and wanted to actually regain their land, there would just be more conflict and tension between them and the current government. So then it's trying to find this real balance, and it's really confusing and complicated, because what is past this? What can we do past this? If we get the land repossessed, what are going to be the consequences of that with the relationship with the Crown government? So then I think it spans off into all of these different issues of politics and relationships. But I do believe rights of nature can get us so far, but there are limitations that I have seen, and I would love to know how to move past them.
Right, okay, thank you. Thank you very much, Iona.
Thank you.
Thank you very much indeed. And I'll now